Please be seated. Good afternoon. We have one case on the docket today, Bayou Bait Camp versus Paul Wasserloos and the Paul Wasserloos and Associates, Inc. We've given both sides 15 minutes to argue. Would the appellant like time for a rebuttal?
Yes, Your Honor, we would request 3 minutes for rebuttal.
We are ready for argument when you are. Yes?
Lectern, Your Honor. All right, thank you. Let's begin. Justices of the court, we're pleased to bring you on behalf of the Prakers and Bayou Bait, plaintiffs and the appellants herein, 2 issues for your consideration. Issue number 1, briefly, is that in the trial of this case, which I'll go over some background briefly in a moment, the trial court improperly excluded literally the core evidence in the case. This ruling deprived the plaintiffs, the Prakers, from introducing evidence proving 2 counts of breach of fiduciary duty, failure to disclose the fact that he was actually not licensed as a CPA and could not do what he was doing for these folks, and as well as putting his own interests above those of his clients, both their fiduciary duties. It's undisputed that as a representative CPA, he had a fiduciary duty.
So the jury answered yes to breach of fiduciary duty. How were you hurt?
They did, very clearly, and I'll go into that. That's 2 extra grounds which they were not allowed to consider. More importantly, that exclusion probably caused a clearly improper result because the jury answered no to what was obviously an intentional interference with the Prakers' relationship with the Christies, which is a contractual relationship. The only possible reason the jury...
What difference would that make if they answered yes to all the other causes?
Well, because that's a separate ground for damage, a separate ground for relief. So
but only one damage question for all your...
Indeed, indeed. So in answering no, that is another issue, but let's get to the real core of the issue. No matter what cause of action supports the damages, the whole underlying basis for the case was the motive for Mr. Wasserloos in lying. So not only was his motive that the jury went to the jury room not understanding why Mr. Wasserloos should be held responsible for what he did because he didn't do anything intentionally wrong. Finally, the jury was actually sent to the jury room on a lie. He was allowed to tell the jury that he was a licensed CPA. And even Mr. Booth argued he's a good guy, did everything he was supposed to do, exactly what he was supposed to be doing. And we're going to get into a little bit more detail in a moment. In essence, though, without any of that, without the benefit of the truth of the case, the core issues in the case brings us to issue number 2, which is that the jury went into the jury room based on false evidence and disregarded the only evidence that was submitted to them regarding damages. So they were given, and this issue was essentially tried by consent, they were given clear, undisputed, uncontroverted evidence of the precise amount of damages that were incurred. Now the Prakers had more damages than that. They elected to go with the amount of actually paid attorney's fees in the litigation caused by Mr. Wasserloos. And that concept simplified the trial, helped with everyone's budget, everyone agreed to that implicitly. I'm not going to represent that they stipulated to it. But this was the basis for damages. Prakers are on the budget. Frankly, I'm doing this appeal pro bono because I felt bad about this outcome. So before I get too far into the weeds on that, just to briefly summarize, the jury was given uncontroverted testimony of the exact damage figure, which was $71,071.49, which were the actual damages caused by Mr. Wasserloos. There was no range submitted. There was no controverting evidence submitted. There was no attacking any particular element of that $71,000 or that it was paid. So Now that we have the issues defined, let's go back and make sure the court is fully reflective of the background of this case. Shortly, I'll keep this very brief. The Prakers and Scott Mock were operating a business together, best friends for life. The Christies were Scott's parents, also good friends. This relationship was sound. And under the cases we'll get to in a minute, the relationship and context for evidentiary exclusions is important and is relevant to the court's consideration. Wasserloos was acting as all of their certified public accountants for years. When Scott was alive, this never came to a head because no one was really paying attention. They're running their business. Scott and the Prakers are getting along. Everything's wonderful. When he unfortunately passed away, the Christies didn't know much about the business or the case. When he died, unfortunately, the Prakers could never understand why the Christies were so hostile and why they sued them, why they wouldn't cooperate with them. As it turns out, the truth of the matter is that Wasserloos was not licensed and authorized to do accounting work. He wasn't authorized to do their tax returns. He could not submit them as a CPA. It was illegal for him to do so. He was a felon. He was suspended 5 times from practicing certified public accounting. He had committed a number of errors and mistakes. He had lied to the Prakers about it. He had lied to the Christies about it. They're key witnesses here. He had lied to the IRS, filed false tax returns, stating that he was the president of Bayou Bait, when in fact, the reason he did that was because if the IRS saw that he's filed it as a CPA, it would have been a felony. So he lied to the state board, and he lied under oath in his deposition. And here's where it gets amazing. The trial court allowed him to lie under oath to the jury without impeachment. He testified to the jury that he was a fully licensed CPA, had no reason to get in between these folks, and did exactly what he was supposed to do. And the jury went to the jury room believing that. When the Prakers attempted to admit this evidence, every time it was shot down. Therefore, the Prakers made their offers of proof, and that's all in the record. Prakers were not allowed to prove that he failed to disclose the fact that he wasn't a CPA to his own clients. That's a breach of fiduciary duty on its own. He failed to disclose that he was, in fact, hiding and secretly blaming his own clients, the Prakers, for all of his own financial malfeasance, and trying to get the Christies and Prakers fighting and hope his own malfeasance would slide under the rug. That's why. That's the why. The whole time the jury went to the jury room, they didn't understand why Wasserloos had a motive to act against the Prakers and why he did what he did. The jury was deprived of that truth. The Prakers were not allowed to impeach his perjury when he sat on the stand and looked at the jury and said, "I'm a good guy and I'm a CPA and I never had any problems with my license." When the evidence was submitted that proved from the records from the state board of, I forget what they call it, the accounting board, state regulatory agency for accounting, proved that he did not and was never authorized to do the work he was doing for them.
Those records are not in the court reporter's record?
They are, Your Honor.
No?
I will try to find copies of them, I don't know if you like, but those were submitted with the offer of proof, and the whole offer of proof is in the clerk's and court reporter's record.
The offer of proof is there, the testimony, but the exhibits are not there.
I apologize, Your Honor. I thought that they were. I'll confirm in a moment if the court will give me leave. I could have sworn those were in the record. In any event, the testimony is clear. Mr. Wasserloos' testimony is in. He said he was a licensed CPA. The expert's testimony says that he checked with the state board, and he wasn't. We were not allowed to impeach him on any basis for that.
Let me interrupt you quickly. So how does the record show that the exclusion that you're complaining about, the licensure issue, caused an improper judgment?
Well, again, it caused the jury to render a no verdict on the tortious interference claim, which clearly he clearly interfered. The question was it intentional or not. Without a motive, the jury found no for the intent. That's one issue. The second issue is lacking any evidence as to the why that Paul Wasserloos did these things, all of these things that jeopardized and caused this entire underlying litigation.
But what difference would that have made if the jury knew what his motivation was?
Well, because when they're looking at the undisputed evidence, they were looking for ways to split the baby when they thought that this was a perfectly normal CPA who was doing everything right and had no motive to
But
harm
how would
the
that make
plaintiffs.
them get lower damages?
I'm sorry?
How would that make the jury award lower damages? I mean, ultimately, that's what you're contending.
Indeed. So the testimony would have reflected that Mr. Wasserloos deliberately undermined the Prakers to the Christies for the purpose of covering his own misconduct, and did so in a way that
How
was
does that
secret.
affect the attorney's fees?
Well, because that's damages. These aren't attorney's fees, Your Honor. These are damages. This is underlying actual damages. There's no Romus analysis. There's no any other analysis. This is by agreed.
But they're attorney's
testimony.
fees as damages, I do understand that, but they are attorney's fees.
Right.
Right.
So every penny of that was testified to by undisputed evidence, was caused and was the sole cause of Wasserloos's interference. All of the things that Wasserloos was doing to interfere with the Prakers' relationship with the Christies, which was kept secret from the Prakers the whole time and ultimately kept secret from the jury. If the jury believes that this is a good CPA who's doing what he's supposed to do and didn't do anything, didn't have any motive to do anything wrong, and he's just a good guy, and maybe he made a mistake, because we did not have the opportunity to get into all the underlying issues. So they think he's a good guy, made a mistake. They're looking for ways to split the baby. Whereas if they understand, they have the actual case that this man set up this entire dispute for the purpose of protecting himself when he was telling everybody he was their fiduciary and CPA, then of course they're going to have a different outlook when it comes to awarding damages.
What do you mean he set up the entire dispute?
There was no dispute pending with the Christies and the Prakers. They were going to work this out. The only reason this went south after Scott died is because Mr. Wasserloos was secretly sending the Christies letters, texts, and emails saying, hey, the Prakers are frauds, they've committed malfeasance, they're defrauding you, they're bad people, they're hiding documents, they're hiding evidence. None of that turned out to be true, but no one understood why.
And that's what caused the lawsuit?
Yes, that's the only reason that the lawsuit happened. So there was no issues.
Okay,
The
but
Prakers and the
what does
Christies
his
were
lack of
friends.
licensure have to do with that, if the lawsuit was caused by his alleged misrepresentation?
Because his license was the reason why he developed the entire scheme. And the entire scheme was not in evidence. The entire scheme started and ended with the fact that he wasn't a CPA. And he had his own serious motives for everything that he did. So there was a whole range of evidence that was never submitted to the jury that goes directly to the amount of damages and to the way the jury approaches the damage question. So you can't have a case go to the jury based on a completely fabricated lie. You're telling them he's Mother Teresa and he's actually, a complete felon. It changes things, and it's not this guy was a bad guy before, so he's a bad guy now.
When you call him a felon, you're talking about an old DWI, right?
Less than 10 years, that's right. But it would also have been a felony, I believe, if he had been discovered or adjudicated to have filed those tax returns improperly, knowing that he was not a CPA. Instead, he lists himself as the president. The jury's going. The jury was allowed to hear that was just a what do you call it? A software error. No harm, no foul. The reason he did that was because it was a felony for him to file that as a real CPA. They couldn't do it. So he's taking everybody's money, the Christie's money, the Prakers' money, Scott's money, everybody's money to be their CPA, and fraudulently filing tax returns, which had other issues, because he wanted the money, and he tried to cover it up after Scott died because he didn't want to get busted, and that's why he did everything he did. That's why this outcome was caused by the no verdict on tortious interference, as well as the jury's attempt to hunt and peck their own discretion on damages, which they have no ability to do. When there's no range of damages, and there's clear, uncontroverted damages in a precise, liquidated amount with no evidence to the contrary, they don't have discretion to ignore that number.
Your time's up. You'll have time for rebuttal.
Thank you, Your Honor. Excuse me, I'll get this out of your way.
May it please the court, I'm Robert Booth on behalf of the appellees Paul Wasserloos, who's a CPA, and his company, his CPA firm, Paul Wasserloos and Associates. This appeal presents two straightforward questions. The first is, did the trial court abuse its discretion in excluding a decades-old disciplinary history, criminal history, for an unrelated business dispute. Second, did the trial court err in refusing to set aside the jury's damages, finding the jury's damages finding and replace it with the appellant's preferred number? On both issues, the trial court ruled correctly and the judgment should be affirmed. With respect to the issue number one, the evidentiary exclusion, the court reviews evidentiary rulings on an abuse of discretion standard, and reversal requires showing that the exclusion probably caused an improper judgment. Here, the appellants argue the trial court erred in excluding Mr. Wasserloo's professional disciplinary history, which was essentially a DWI conviction. I will say that the reason that this was so prejudicial is because the DWI conviction, I believe, was more than 10 years old. But what happened is that Mr. Wasserloo got involved in a child custody dispute where the mother of his child made an allegation in 2016 of an inappropriate touching. That caused his probation to be revoked and caused him to go in jail, caused the license to go under review. Thankfully, Mr. Wasserloo was acquitted of those charges, and that's why he had a license at the time of the trial. And for the court's information, he has full custody of his daughter today. So,
what is the appellate effect of not having the exhibits as part of the court reporter's record?
Well, I think that under Cochran, the case, that if you don't have an entire record, they have to. The appellant had to specify the issues that he was going to raise on appeal. That was not done. I'll review the court supplemental record, and it indicates that it's just a letter to the district clerk stating that he has arranged for payment of the record with the court reporter and has not stated the issues. Furthermore, I agree that the record does not contain any of the exhibits, but it does contain one exhibit. In the JNOV, it does contain the plaintiff's exhibit on attorney's fees, and I think that the jury, in looking at those attorney's fees records, can look at those entries and decide which of those entries were related to the Christie dispute. And I do take a strong opinion or strong stance that the Christies, who I think were probably the most credible witnesses in this trial, they are the parents of the decedent. They testified about two critical things about why this dispute arose. First, the evidence was that Mr. Scott Moss, who was the business partner who passed away, got into a very big dispute with Billy Praker, the plaintiff, at the Christmas immediately preceding his death. So about a month before his death, there was a big blow-up between Mr. Praker and the decedent. And second, the Christies testified, and Carol Christie testified about she was at her house and she was confronted very angrily by Billy Praker, yelling at her and very aggressively, and that was what caused the disputes. Both Carol Christie and her husband testified that nothing that Mr. Wasserloo did had any effect on their decision to file a claim. I mean, they were the heirs of Scott Moss. They became owners of this business. They testified they did not have any desire to run a bait camp business. Both the Christies are retired. They knew there was going to have to be a buyout, and the jury was entitled to hear that evidence and then look at the attorney's fees records and determine, was that evidence of attorney's fees damages that were caused by the conduct of Mr. Wasserloo. Here, the jury knew that Mr. Wasserloo had listed himself as an officer on corporate documents. They had heard appellates repeatedly attack his credibility. A CPA expert testified that Mr. Wasserloo didn't follow procedure by withdrawing and actually had a conflict of interest. The jurors were free to doubt Mr. Wasserloo's testimony. The testimony that was barred by the court was cumulative. It would just add heat to the argument, not light. The excluded evidence had little probative value because of appellate's claims like defamation and tortious interference did not hinge on Mr. Wasserloo's licensing history or his prior felony. At best, it touched only on his general credibility, which is not permissible under Rules 403, 404, and 608B. Trials are decided on the specific facts of a case, not a catalog of past bad acts, which is what the plaintiffs and appellates tried to do here. The trial court was well within its discretion to keep out the inflammatory collateral matters that would only have distracted and caused prejudice.
Was he a licensed CPA at the time that he testified?
Yes, he was.
Fully licensed?
He was licensed. He was licensed, and he testified to that. He had been on a limited scope, and I think that's important that in 2016 he was on a limited scope. That the fact that he was on a limited scope has no bearing on the Prager's cause of action, because their own CPA expert testified that to prepare tax returns, which is all that Mr. Wasserluis was doing, you don't need a CPA license to prepare tax returns. There's plenty of tax return shops out there where they're not licensed CPAs. Mr. Wasserluis was very clear in his testimony that he did not step over the line to perform the professional type services required a CPA license.
If he could file tax returns, why did he, I guess, hold himself out as the president of the company?
So Mr. Wasserluis explained that.
Okay.
He explained in his testimony that he had a software glitch that inadvertently listed him as an officer of the company. He testified that he never took any action as the president of the company. It was just a software glitch. In fact, it happened on a whole number of his returns. It wasn't just on returns that he did for other clients. It was not just the Prager's company or the company at issue in this case.
And he filed tax returns for the Prager's company?
Yeah,
and he signed them as the preparer?
It's just a digital. It's just like a printed. We don't have the exhibit in the record, of course. It's just his name printed. It's a form that kicks out from a software, and it printed his name. I think if I understand it correctly, it's a government promulgated form, and they have to have a signature by something, and it pulled the wrong field from his software where he was the CPA, and it was matched wrong and identified him as an officer of the company. But Mr. Wasserluis testified that he had never taken action as an officer of the company, and it was just a mistake.
Did the jury know that he was on a limited scope CPA in 2016? Did they know that?
I don't think so. I don't think that they knew he was on a limited scope, but they did hear the CPA testify you don't have to have a CPA to prepare tax returns. There were 2 times when opposing counsel did get into the fact or call Mr. Wasserluis a criminal, in front of the jury, and so I think that definitely the jury had a sense of things that were going on. With respect to issue number 2, a JNOV is reviewed under a legal sufficiency standard, and it's proper only if a reasonable juror could have reached the verdict on the evidence presented. Here, the appellants argue that the court should have disregarded the jury's finding of $7,600 in attorney's fees damages and substitute the full $71,000 in attorney's fees. Again, just because we only have excerpts of the record, I think that the court, under the Bennett v. Cochran case, Texas Supreme Court case 2002, that the court must presume that the missing portions of the record support the trial court's judgment. That's an independent basis to affirm here. Certainly there's a little bit of a causation dispute here. The jury heard that the appellants claimed the fees stem from an internal dispute between the Christies and from probate issues and from a routine restructuring following the death of one of the business partners. Those are all things that are going to be necessarily incur legal fees with a profitable business. And someone dies as a partner, there's going to be legal fees. Not all of those legal fees, I think the jury was rightly entitled to determine, were because of a dispute between the Christies that was caused by Mr. Wasserluis. Also, I think that the credibility of the expert witness that provided the attorney's fees evidence, I would not say this was uncontested. There was a pretty strong cross-examination of the attorney's fees witness and the records. In particular, it happened on the record, but I asked the attorney's fees expert if he is familiar with the War Moves Ventures case. He didn't. 2 pages later in the transcript, he's actually Googling War Moves Ventures from the stand because he was not familiar with it. I think that the jury was entitled to question the credibility of the expert witness sponsoring those attorney's fees, and they did so. The jury has a prerogative where they can actually go through the attorney's fees exhibit and look at it and look at those time entries, and they don't have to either give 0 or 71,000. They can look at those time entries, and if you look at those time entries, it's replete with time entries that have nothing to do with the dispute between the Prakers and the Christies. On one clerk's record 240, there's a discussion about drafting LLC documents. There's a revision of the company agreement on one clerk's record 241.
So you want us to look at this document?
Even
though it's not part of the
it's part of the clerk's record. It's not part of the
The
problem.
attorney invoices.
It's just the attorney invoices, and so obviously the first argument is the clerk's record is incomplete, and you would presume that it would support the judgment. But if the clerk, I'm just recognizing that the attorney's fees invoices are technically in this appellate record, in the clerk's record, they're attached to the JNOV. And I'm as a backup argument,
And you don't dispute that they are, as they are attached to the JNOV, that was how they were introduced?
Yes.
Okay.
Yeah. I don't have any way to dispute that, but there's you know, on the clerk's record, 249, there's a series of emails about corporate restructuring, emails about highway work, clearly things that are not related to a lawsuit between the Christies and the Prakers. And furthermore, the jury, when the jury gets a question about damages, it can consider the causation. The question is not if you found breach, automatically award the damages. It's that the damages are caused by the breach, and that's part of the jury's prerogative in being able to go through and answer its question. They did so here, and so we think that the attorney's fees judgment, that the judgment should be upheld. I will say that this issue about whether or not Mr. Wasserloos had a motive to somehow hide the problems with his license, motive is not an essential element of the cause of action here. It's harmless error. Mr. Wasserloos got tagged for 2 breaches. He got tagged for breach of fiduciary duty and a breach of contract, 2 serious claims, and the jury awarded damages. So I don't see how, if they had found a tortious interference, that would have resulted in a different measure of damages or affected the measure of damages in any way. Let's see. I do want to circle back that the first point that we raised in our brief is that much of the appellate's briefing is conclusory or lacks record citation. That's understandable because none of the exhibits are on the record, but I would think that would constitute a waiver under Rule 38.1. Let's see. I do want to talk just briefly about some of the evidence about the dispute and how that was not caused by Mr. Wasserloos. Mr. Moss died without a will. That's at the 4 Reporters Record 29. At the Christmas of 2019, there was a big dispute. The Christies, after Scott's and Mr. Moss's death, were trying to get information from Tanya Praker, one of the principals of Bayou Bay Camp. She refused to provide it. That caused Billy Praker to come over and have this big dispute. The Christies say that when they decided to settle the lawsuit between them over ownership of Bayou Bay, that they never saw Mr. Wasserloos's deposition, and that didn't play a role in the settlement. That's at 4 Reporters Record 91. There are replete things that this was really just a natural occurrence of a fact that a business partner died and somebody else came in, and the Prakers didn't want to be in business with the Christies. That is a natural thing where lawyers are going to have to get involved to unwind it, settle it, transfer the ownership share. That has nothing to do with Mr. Wasserloos. And so for those reasons, I would ask that the court affirm the judgment below. It's truly an honor to appear before you here today. Thank you.
Thank you.
If you have any other questions, but that's all I have. Thank you.
Approach, Your Honor. Your Honors. Thank you. I'm going to try and be very brief without speaking so fast that I can't be heard. First, with respect, I apologize, I wasn't able to confirm the clerk's record. My recollection is that it's there, but certainly the reporter's record is sufficient as it stands, and the appendices do contain, without objection, the relevant State Board of Examiners records, as well as the clerk's record. If it was not filed, then it's certainly my apologies. With respect to Mr. Booth's main argument, the Christies, talking about how critical their testimony is. Well, let's be clear. The jury was not allowed to hear, and neither were the Christies, all of the things that Mr. Wasserloos did wrong that were excluded. Christies didn't know that, never knew that. So they didn't know he wasn't a CPA. They didn't know he had a reason to lie to them. They didn't know any of those things, and that's why their testimony was tainted by this exclusion just as much as the jury was. Everybody in that courtroom knew what Mr. Wasserloos did wrong, except the jury and the Christies. So, with respect to...
It sounds like the Christies had to sue anyway to get the interest worked out.
No, not at all. That would have very clearly been resolved. They never were given a chance to even meet because of the underlying.
They're the ones who sued to begin with, right? The
Correct,
Christies.
that's the underlying lawsuit.
Right.
But the reason they sued is because they had Mr. Wasserloos telling them that the Breakers were defrauding them, which was a lie.
But they denied all of that, right?
Because they didn't know that he had denied, they didn't know that he wasn't licensed, they didn't know any of those things, all that was excluded, we couldn't even cross-examine them on that. So the jury went in there thinking that the Christies and Mr. Wasserloos were just normal people with their CPA, when the reality is very different. Real quickly, the law on this, I don't think the parties are disputing the law that's applicable very much, but I want to be sure it's very clear here. This evidence is presumed admissible. The JBS case, the Keller case that he cites, the Gulf case, very clear. State of mind is critical evidence. Evidence that goes to why a defendant can't meet or didn't meet their standard of care is critical evidence. Evidence as to the core elements, such as he's self-dealing, he concealed this information, that's a breach of fiduciary duty. Evidence as to his intent, that has to come in. And further, on the damages side, similarly, the jury may not ignore clear, direct, undisputed, uncontroverted evidence. There is
Yeah,
no...
but how do you respond to his point that the invoices that were introduced contained entries that didn't pertain to the lawsuit?
Well, he did attempt to cross both me and Ms. Praker on that. You didn't see it in the record because the undisputed evidence from all the witnesses was that every itemized issue that he took issue with was very clearly caused by Mr. Wasserloos's conduct and was made necessary because of the dispute that he created. There was no controverting evidence. His questions are not evidence, and his closing is not evidence. And his argument here, which unfortunately contains some misrepresentations, he was not, as of the time of the trial, or as of the time from 2015, 14, all the way to when Scott died and thereafter, Mr. Wasserloos was not allowed to file tax returns. He was not allowed to practice accounting. He was not allowed to advise in business or corporate structure. He was not allowed to give tax advice, ever. And so that evidence should have come in, and it probably caused this verdict to fail to meet the standards of justice and to give the Breakers their due. So we would request that respectfully request that the court either reverse and render, and that'd be an efficient way to do it, put in the only evidence of damages, which is an exact figure, $71,741.49, or in the alternative, to reverse and remand, because any jury that's going to award damages in this case or evaluate tortious interference in this case is entitled to know that this man was not licensed and he was lying to them. He perjured himself. He was lying to the Christies, lying to the Breakers, lied to them, lied to the court, lied to the deposition, and that evidence was all excluded. The jury went in on a lie. Thank you, Your Honors.
Thank you. This case is submitted and we are adjourned.
All right.